It is called to mind by defendants pending motion to disqualify this court. When you can't attack the message, attack the messenger. Oh, great opening phrase there, Judge. Oh my gosh, she's gonna bloviate herself into the sky. That this country has an independent judiciary that adheres to an impartial adjudication process without being swayed by the president.
We would expect them to regulate themselves and say, we cannot do this. It gives the appearance of impropriety, and in some cases, it actually reinforces the biases that they have.
A Trump-hating judge refuses to recuse herself. Big, giant surprise, I know. This is, of course, coming out of the District of Columbia. It is involving the case of, in my opinion, the corrupted law firm Perkins Coie suing the Department of Justice. Trump came out, issued an executive order, and said, get out of our government. We don't want you here because you employed hacks like Michael Sussman and Mark Elias to try to rig an election and operated slews of lawfare against Trump specifically and said, you're done. We don't have to do business with you, so you're cut off. So Perkins, a bunch of babies, sued and said, well, how dare you remove us? We want to be friends. Like, you were just stabbing him in the back like 35 times every time he turned around. What's wrong with you? So they're suing to try to bring back their connection with the government, to try to reforce these relationships to open back up. Now, this case got assigned to another corrupt judge, in my opinion, Howell, who we've seen and talked a lot about here. This is who she is and what she looks like. Was the chief judge from 16 to 23. As the chief judge, she supervised a bunch of anti-Trump stuff. Mueller, 2016. Attempts to overturn the election in 2020. And has given speeches against Trump in multiple clips that we've played here. So we know who she is. Now, Trump submitted on demand that she recuse herself based on her statements, based on her speeches, and her all-around partisan hackery. And she has responded today, and she writes the following from Judge Beryl Howell. Though this adage is commonplace and the tactic overused, it is called to mind by defendants pending motion to disqualify this court. When you can't attack the message, attack the messenger. Oh, great opening phrase there, Judge. The adage is commonplace. It's very basic, Judge. You're acting basic right now. So they say Trump filed this motion less than 2 weeks after the court issued a TRO, stopping Trump from enforcing the order against Perkins Coie. 3 of the 5 sections she halted. Targeting, saying you can't target law firms with punitive measures because the president dislikes them. Now, when the Department of Justice engages in this rhetorical strategy, writes Beryl, of ad hominem attack on the judge, I guess, the stakes become much larger than only the reputation of the targeted federal judge. Okay, so now she's a victim. This strategy is designed to impugn the integrity of the federal judicial system. Oh, no. You've done that to yourself, Judge Howell, and blame any loss on the decision maker rather than the fallacies in the substantive legal arguments presented. This is wild. So this judge, like this full paragraph, is basically attacking the DOJ and their strategy rather than addressing the merits of the argument. The opportunity presented by Trump's motion to disqualify me is welcome. Oh, here it is. To set the record straight. Oh, gosh. So it's going to be one of those conversations. I just want to talk with you. Why? I just have some things I want to say. All right. Because the facts matter. We're going to have a hard time getting through this. To begin, this court agrees wholeheartedly with Trump that fair proceedings from any suggestion of impartiality are necessary. That's true. So she agrees with us. She should recuse herself. No judicial ruling exists in a vacuum, but rests on case or controversies that are presented here. And everybody is entitled to an impartial hearing. That fundamental promise, but does not entitle any party to demand adherence to their own version of the facts and their preferred legal outcome. She's nuts, man. Howell's nuts. Fact-finding, after all, is the basic responsibility of the district courts. Yeah, but we want a nonpartisan judge. That's the point, to do the fact-finding, not a hack who hates Trump. She says, this reminder about the role of federal courts seems necessary. She says, it is emphatically the province and the duty of the judicial department to say what the law is. Yeah, nobody's arguing that, lady. We want an impartial person to do that. That's the point. So again, she hasn't even gotten to anything substantive yet. This reminder about the role of the federal court seems necessary given the open line in their pending motion. Trump said that they need to curtail the ongoing improper encroachments of Trump's executive power playing out around the country. So this line, which sounds like a talking point from a member of Congress, which is rich coming from a judge who sounds like a Democrat member of Congress, rather than a legal brief from the DOJ, that's rich, Judge. You sound like Chuck Schumer. Kind of look like him too. No citation to any legal authority for the simple reason that the notion expressed reflects a grave misapprehension of our constitutional order. Pathetic. Judge, you're in Article 3, all right? Not Article 2. Adjudicating whether the executive branch exercise of power is legal or not is actually the job of the federal courts and not of the president or the DOJ, though vigorous and rigorous defense of executive. Okay, she shouldn't have jurisdiction over this case either. This is Perkins Coie suing because a contract got canceled. It's a contract claim. She she shouldn't be hearing this at all. Perkins should go file in the Court of Federal Claims. So again, this judge is going to do the same dang thing that the Democrat lawyers do, which is wrap their broken contracts and broken hearts up in constitutional complaints and then make believe that it's a constitutional lawsuit. They're upset their contracts got canceled. This blanket denigration of the merits of these lawsuits reflects palpable frustration, says this judge, with the courts to pause or temper the Trump administration. But it's a testament to the fact, oh my gosh, she's going to bloviate herself into the sky, that this country has an independent judiciary that adheres to an impartial adjudication process without being swayed by the president. So we're on page 3. She hasn't even gotten to the complaint against her yet. While obviously not able to speak on the merits of all cases around the country, Trump is posturing. When facts or applicable law appear here, she's talking about other cases. In another case, the government said there were binding facts here. The DC Workit is warned that consideration of a motion for disqualification is never taken lightly and can't be supported by innuendo and stuff. But here, okay, finally, we get here, page 4. They only rely on speculation and innuendo. Let's see if she addresses it. Here's the legal standard. A judge must disqualify when their impartiality might reasonably be questioned. Lots of case law there, we know. And she says, now defendants here, Trump, base their disqualification motion on Beryl Howell's systematic disdain for Trump. Now they say, although, she says, this is rife with innuendo, none of these complaints meet the standard for disqualification, saying their claim that this court's dismissal of pending charges against the J6ers showed hostility, right? One of the things that Beryl Howell did was like rant about the J6ers. But she says it wasn't grandstanding, saying the crux of the critique appears to be the fact that in explaining the decision to dismiss, the court did not adopt the presidential reasons for dismissing the case. Whatever reasons that the president gives, they're unreviewable by the courts, but she's basically going to say, I'm allowed to say what I want in dismissing the claims. Decisions from the DC court finding that recusal was not warranted also means comments. Comments are protected. I shouldn't be required to recuse because I said some bad things about Trump. Saying defendants are also relying on 2 other decisions, but these examples are not appropriate. They also say that this court questioned Twitter's counsel and then allowed access to Trump's DMs. We covered that problem here. But this is just mischaracterizing this line of questioning. Okay, they're taking me out of context. The second grand jury decision was about subpoenas and testimony and could have remained under seal, but Trump asked for it to be publicized. And so there are no issues here. The judge also broke attorney-client privilege, as you recall, and she's saying, I found that legitimately and everything I did was legitimate. In sum, mere disagreements with prior legal rulings is not a valid basis for disqualification. All right. So defendants also point to a single line in a speech. Remember, she gave a speech, and in the speech, she came out and was talking about Trump's big lies. They say in further emphasis, a single line of a speech saying that she regularly sees the impact of big lies is not enough. Contrary to their assertions, this speech never mentioned Trump. I wasn't talking about him. This speech never took any political positions at all. Not talking about 2020. The extent that they suggest otherwise, oh, I wasn't talking about Trump. The fact that you think I was talking about Trump means that you were talking about Trump. She's so pathetic. The Supreme Court has long recognized that judges are not only permitted to talk about their views, they can have candid reflections. And so here, just because I worked on the Mueller case and the Russian collusion hoax and all of these other things, and Fusion GPS and the Mueller investigation and the PP tape and more, the court is not biased, and these are not grounds for disqualification. And so for the reasons addressed here, we are not going to disqualify myself. All of this is based on speculation, innuendo, and basic legal disagreements, not a basis for disqualifying Beryl Howell. All right, so it's so ordered. Trump loses the motion to disqualify Beryl. Beryl gets a motion and a complaint about herself, reviews the complaint, finds she did nothing wrong. Judge Beryl Howell, one of the worst out of DC, going to stay on the case. So will Congress do anything? Here's what one representative, Andy Biggs, had to say about it.
Exceeded it. Maybe Congress should make a resolution that you violated the good behavior clause of Article 3, Section 1. The other aspect is getting to the nub of it is we would expect them to regulate themselves and say, we cannot do this. It gives the appearance of impropriety. And in some cases, it actually reinforces the biases that they have. And so you're not seeing people walk away. We've seen that in the J6 cases in particular. You saw a lot of that, John.
That's right.
And so it's really actually kind of a horrific thing. It adds to the mistrust that Americans have in their government and, in this instance, in their judicial system, the system of justice, oddly enough. They don't trust the system of justice.
It's a shame, and it's because of judges like Beryl Howell and the rest of them in Washington, D.C. So we're going to keep our eye on this one. We'll see if Trump appeals this. I mean, ultimately, I think a lot of these things will get rectified on appeal, but we'll be here continuing to cover it. Thank you for subscribing and joining as we do.